welcome to this evening's Mansfield public talk. My name's Helen Mountfield, I'm the principal here, and this evening's public talk is our annual Jonathan Cooper Memorial Lecture. We hold this lecture every year in memory of Jonathan Cooper, who was a very distinguished human rights advocate and who sadly died 3 years ago. And he, when he died, he was working with us to help to fund a chair in the history of sexualities, which is now named the Jonathan Cooper Chair. But we also hold an annual lecture to reflect on other things that interested Jonathan, and human rights and democracy were very much at the centre of that. And this lecture is kindly funded by Sigrid Rousing and her foundation. I'm delighted that this evening our Jonathan Cooper Memorial Lecturer is a very distinguished human rights lawyer and also somebody who was a friend of Jonathan's. David Cole, the Honourable George J. Mitchell Professor of Law and Public Policy at Georgetown University in Washington, D.C., a pretty hot seat, I would have thought, at the moment, especially for somebody who was the legal director, the national legal director of the ACLU for many years. And in the polymathic way of an American academic lawyer, which people in this country often envy, he's not only has been an advocate of the ACLU and is a very distinguished academic, but also writes regularly for the more general highbrow press, the New York Review of Books, and he's the legal affairs correspondent for The Nation. He's written some fantastic books. The one I always recommend to people who think that strategic litigation is just something that good people do, and as Frederick has an end in sight, is a book called Engines of Liberty, which is about the power of citizen activists to make constitutional law, and looks at case studies, one which is about equal marriage protection, and the other of which is about the uses of the law by the National Rifle Association. But David has also litigated a lot of path-breaking cases in the Supreme Court as the advocate himself, and these include Texas and Johnson, which extended First Amendment protection to free speech rights to the act of burning flags, Bostock and Clayton County, which was the case that established that Title VII bans on discrimination also banned discrimination on basis of transgender status and sexual orientation, and the National Rifle Association and VULO, which held that government officials can't use their regulatory authority to coerce private parties into blacklisting a disfavoured political organisation. Quite interesting in the light of some of the uses of immigration law in the United States and Harvard at the moment. So David has received a number of awards for his civil liberties work. I've heard him speak on a number of years ago on the uses of law, and I'm looking forward very much to his talk on Donald Trump's attacks on the Constitution, neutrally named the Unhinged Presidency. I'm really looking forward to it. Thank you very much, David, for speaking to us.
Thank you, Helen, for that generous introduction. And I'm really honored to be here, and particularly to be giving the Johnny Cooper Memorial Lecture. I knew Johnny both professionally through human rights work in his capacity at Liberty and Justice and the Human Dignity Trust, but also socially. And my most distinct memory of Johnny was we were in Devon, and he led a group of us on a tour of Agatha Christie's house. And he knew more about Agatha Christie's house than I think any human being in America, in the world, and gave us an incredible tour. So he may have missed his calling by going into law, but he was a fantastic person, a fantastic lawyer. So I'm really honored to be giving this lecture in his memory. My subject is Donald Trump, and I come at this from a perspective of having been very much involved in Trump 1.0. I became the National Legal Director of the ACLU about 9 days before Trump took office. And I was actually, I applied to become the National Legal Director of the ACLU in the spring of 2016, and the Executive Director of the ACLU came down to Washington to encourage me to apply. And he said, how could you not apply for this job? You've been doing constitutional law, teaching, advocating, writing about constitutional law for your entire career under a conservative majority Supreme Court. Just think what it would be like to lead the ACLU and its Supreme Court work in particular under a liberal majority Supreme Court. Because, and that's why I applied, because in the spring of 2016, what we all knew was that Hillary Clinton would of course win the election. Donald Trump had no chance, and she would then appoint Justice Scalia's successor. He had died and his seat was open because the Republicans refused to let Obama appoint Merrick Garland. And that would have made the court a 5-4 Democratic appointed liberal court. And so I said, sure, and I applied and I got the job. And then after I got the job, I was still finishing my teaching at Georgetown. Something happened in November of 2016 that changed the job dramatically. But incredible time to be at the ACLU fighting back against the kinds of threats that he posed to immigrants, to transgender folks, to people of color, really across the board. And we are the sort of biggest across-the-board civil rights and civil liberties organization in the United States. And so it was, much of the fight was on us. But I'm going to talk about Trump 2.0, which is in many respects another phenomenon altogether. There are some similarities. He's still targeting immigrants. He's still targeting transgender folks. He's still targeting people of color. But now he is targeting the system of checks and balances that worked to push back against him the first time around. He is directly targeting the institutions of civil society that play a critical checking role in our constitutional democracy. So I want to make 4 points about this sort of phenomenon. First, that this is what's different about Trump 2.0. It's about seeking to disable the institutions that exist in a constitutional democracy to check abuse of power. That's first. Second, what will save us from Trump 2.0 are those institutions of civil society. They did the first time around. They are performing they have a somewhat mixed record this time around, in part because of this, in significant part because of this attack. Third, that Trump's attacks on civil society and the institutions that check government abuse have revealed some real vulnerabilities in those institutions. They're not as powerful as I think we assumed they were at one point. And then finally, that the institutions that check government abuse in the United States are interdependent and can be, and at their best, are mutually reinforcing in ways that can overcome these vulnerabilities. So first, sort of what's different? How has he gone after checks and balances? Well, he's gone after checks and balances in a variety of ways. First, within the government, within the executive branch, he has fired one of the first things he did was fire all the inspectors general, which are positions within the executive branch that are designed to be places where people could go to complain about people who are violating the law within the department. He's fired all sorts of folks who might have some independence from him and put in their place people whose principal occupational strength is their loyalty to Donald Trump, not their ability to run a department. Many of them are more familiar with Fox News than they are with running a governmental agency. So internally, he has sought to do what he can to push out internal critics, to hire only loyalists. Externally, he has attacked the institutions of civil society, and particularly lawyers, universities, the press, and unions. And these are all institutions of non-governmental institutions that play an important role in a democracy, in being places where people come together with a certain set of commitments, are independent of the government, and use their collective power to watchdog the government, to criticize the government, to seek change from the government, and the like. And so, and as I said, last time around, those entities played a critical role in checking what President Trump sought to do, and I'll talk about that in a moment. But what this time around, what he has done is to attack those very entities. And I think this is absolutely critical, because when you look around the world, virtually every country in the world has a written constitution. I'm not sure about yours, but every country in the world has a written constitution, and most of them look at least as good as the U.S. Constitution, which is kind of old-fashioned at this point, on paper. But many of them, the Constitution is only on paper. It's not real. It doesn't have bite. And in many instances, that is because civil society in those countries it doesn't exist in the same robust way that it does exist in the United States. And so I think a critical part of our constitutional democracy are the civil society institutions, the NGOs, the universities, the press, and the like, which play this checking role and make the words on the page of a constitution into something that is real. So as I say, Trump has attacked these very entities. Law firms. If you're going to engage in a lot of illegal conduct, you might want to disable the lawyers who could challenge you. And so one of his first initiatives was to go after the law firms that he didn't like. And he put it right on the face of executive orders. He would issue an executive order concerning Perkins Coie was the first one, a law firm in D.C. a major corporate law firm that does all kinds of work. And it says, well, you do all kinds of work, but you have represented transgender people, and you have represented people challenging voter ID laws, and you have hired lawyers who have sued me. And so I am going to take away all security clearances of all people in your firm. I'm going to bar any federal contracts with your firm, and I'm going to bar every lawyer in your firm from entering any federal building. So it's pretty hard to practice law if you can't enter a federal building. These are blatantly unconstitutional, retaliatory attacks on law firms for doing what they're supposed to do, bringing lawsuits. Universities. He first froze $400 million in federal funding to Columbia. He has since frozen $175 million in federal funding to the University of Pennsylvania. He's frozen over $2 billion in federal funding to Harvard. He's now, in the wake of Harvard fighting that freeze, is seeking to deny Harvard's ability to have any foreign students at Harvard, and Harvard has about 28% of its student body are foreign students, and they would, if this is upheld, I don't think it will be, if this were upheld, they would lose all those students, and students who are there now from foreign countries would have to transfer, find some other school and transfer to that other school. These attacks are allegedly for anti-Semitism and anti-Americanism on these campuses, but they have led to the president issuing demands to these entities that violate core principles of academic freedom and are totally unconnected to any particular incident of alleged anti-Semitism or anti-Americanism. So, for example, he would have required Harvard to get rid of its DEI, all DEI programs. Well, DEI programs, diversity, equity, and inclusion programs, what do they have to do with anti-Semitism or anti-Americanism? Nothing, but he doesn't like them, so he wanted them to get rid of all their programs. He wanted them to use a litmus test and make sure that any foreign student who came to study at Harvard was not anti-American, whatever that means. He wanted Harvard to give the federal government the power to oversee its hiring of faculty to ensure that the faculty were ideologically diverse. The federal government was going to oversee the hiring of faculty by a university. Direct assaults on academic freedom. Harvard, thankfully, is fighting. Columbia, unfortunately, capitulated, and other universities are going to have to make their decisions. The press. He's gone after the press. He's in some sort of trivial and kind of ridiculous ways. For example, he has excluded the Associated Press from the press pool that has access to the Oval Office and Air Force One when the president is doing official stuff. Why? Because they still call the Gulf of Mexico the Gulf of Mexico. And he says, no, it's the Gulf of America. And since you call the Gulf of America the Gulf of Mexico, you are excluded from a press pool that you have been a part of since the beginning of the press pool. The FCC, his FCC chair, the Federal Communications Commission, which oversees, among other things, broadcast licenses, has threatened to deny broadcast licenses to stations that are not that are too critical of the president or have viewpoints that are too liberal. The Trump administration has cut off funding to public television and public radio, the Corporation for Public Broadcasting and National Public Radio, again, because he disapproves of the political viewpoints they have expressed in doing their job. And then public sector unions. Public sector unions have been very active in pushing back against many of the efforts to fire longtime civil service employees, to shrink radically various government agencies. And so he has sought to destroy the public sector unions by declaring their agencies national security sensitive, which then bars them from even having a union. So Trump has gone after internal checks, he's gone after civil society, and then the third thing he's gone after is the courts. So courts, obviously, in the United States, independent, life-tenured judges, their role is to decide cases, without favor or fear or favor for either side, and to check government abuses. And they have done so in many cases, and I'll talk about some of them in a moment. But this has led President Trump to threaten the courts and to do everything he can to evade the court's rulings. So he has called for the impeachment of judges who have ruled against him, prompting Chief Justice John Roberts, a very conservative justice, to speak out, very unusual for the justices to speak out other than through their opinions, to speak out against the president for his targeting of a judge for impeachment simply because he ruled against the president. He has questioned whether there ought to be due process or trials for immigrants who he seeks to deport quickly, and turns out trials take a long time, so he'd like to get rid of them altogether. And then he has evaded basic court decisions. So I'll just talk about two. The first is a case, an ACLU case actually, involving the president's invocation of the Alien Enemies Act. The Alien Enemies Act was passed in 1789. It is designed for use during wartime. It basically says when we're in a war with another country, you can either detain or deport nationals of the country with which we are in a declared war. It was used during World War I. It was used during World War II. It has not been used. Since then, we haven't been in a declared war. We've been in plenty of wars, but no declared wars since World War II. And you know, the idea is, well, if you're in a declared war with a country and the person is a national of that country, they might be disloyal, and so you got to give the government fairly broad powers to deal with them. I think England has a similar, or at least had a similar authority during World War I and World War II. I don't know if you still do. Trump has invoked it against a gang from Venezuela that not only are we not at war with, nobody even heard of until he invoked the Enemy Aliens Act and claimed that they have invaded the United States on behalf of the Venezuelan government. Recent reporting has disclosed that the national security agencies in the federal government, when asked whether this gang was invading us on behalf of the Venezuelan government, said no, which then caused the political operatives to require them to rewrite the memo to not undermine the president's bogus claim that that we are at war with a gang that nobody ever heard of. So the ACLU got wind that this was going on, and so they filed an emergency case on a Friday night, late on a Friday night, and a judge in D.C. Scheduled a hearing for the next day, Saturday. Not very common that the judges work on weekends, at least hold hearings on weekends, but emergency because the ACLU said we have reason to believe he may be trying to deport some people using this. So the hearing started at 5 o'clock. The first question the judge asked the government lawyer was, are you planning to remove anyone? Because I need to know that as we're going forward with this hearing. The judge says, I don't know. I mean, the lawyer for the government said, I don't know. Said, what do you mean you're representing the United States here? You don't know? I don't know. So the judge said, okay, we'll take a half-hour break. And you find out in that half hour whether you are planning to remove people, in any immediate time frame. They take a half-hour break. During the half-hour break, 2 planes take off with 150 Venezuelan folks. Come back in half hour later. What did you find out? I can't say. The government lawyer says, I can't say. Can neither confirm nor deny. It's a secret. The judge says, well, you can come back behind closed doors and tell me, I'm a judge, I can hear this information. No, I can't tell you. The planes had taken off during the recess in the hearing that was to decide whether the government had the authority to use this act at all to deport these folks. So the ACLU says, we have reason to believe that they are actually taking off, and the judge says, well, I don't know, but if they have taken off, turn the planes around, or when they land, come back. Don't, offload these folks because they're in your custody. Bring them back. Before we rule on whether you can deport them, you can't deport them. And the Trump administration did not turn the planes around, unloaded all of the men and 8 women, who were then the men sent immediately to a horrific, essentially torture chamber in El Salvador. The women, they did bring back, but not because the court had said bring them back, but because the prison in El Salvador didn't accept women. So they brought them back. So they clearly could have brought everybody back, but they chose to bring back only. When the judge started, asking questions after when this came out, started asking questions about what happened. Did you violate my order? The government invoked state secrets privilege, said we can't disclose when the planes took off, where they flew to, even though the White House had retweeted a 3-minute video that had been put out first by Bukele in El Salvador, showing the planes taking off, showing their numbers, showing the time when they took off, showing them landing. It's a secret we can't disclose. The second case is a case involving a man named Abrego Garcia, a Salvadoran man, who was mistakenly deported to El Salvador. He was from El Salvador. He did not have a visa to stay in the United States, but in immigration proceedings, he had obtained an order that he couldn't be removed to El Salvador because he feared persecution by a gang in El Salvador that was the reason he came to the United States in the first place. So he had protection from deportation. They didn't realize that. They sent him on that same plane with the Venezuelans. And for the last month or so, the courts have ordered the president to bring this guy back, to facilitate his return. And thus far, the president has failed to do so. Initially, he refused to even ask for him to be back, and he said, well, I interpret facilitate to mean we won't stop him from coming into the United States if he shows up at the border, but we don't have to do anything vis-a-vis the government of El Salvador, who we are paying to detain him in El Salvador. They then, there was some pressure for that, including from the Supreme Court. So then they asked the president of El Salvador to return him, but with a nod and a wink, evidently, and the president reportedly said no. Shortly thereafter, a reporter asked President Trump, could you get Mr. Abrego Garcia back? And he said, yeah, of course I could get him back. If he were a gentleman, I would get him back. But he's not a gentleman, so I won't. The court order did not say, get him back if he's a gentleman. The court order said, get him back, and the president is dragging his feet there. So these measures, the sort of sweeping away checks and balances inside the executive branch, in the society at large, undermining the checks and balances from the courts, are, of course, familiar, right? They come out of the playbook that many autocrats have used when they've come to power to sweep away opposition. Among them, Putin in Russia, Orban in Hungary. And these are the very checks and balances that worked last time to rein in President Trump. The last time around, President Trump had the worst won-lost record in the Supreme Court of any president since the first term of Franklin Delano Roosevelt, when he was putting in place all sorts of progressive legislation, and a very conservative court was striking it all down. the court barred efforts to put a citizenship question on the census, which was designed to depress responses from Democratic strongholds. The census is a constitutionally required counting of population, not of citizens. He then said, well, I'm only going to report. I can't put the citizenship question on the census, but I'm only going to report the citizens. The court stopped that. They stopped him from denying opportunities to apply for asylum for people coming to the United States from the southern border. They enjoined his program of his cruel program of separating immigrant families, taking young kids as young as 1 year old and detaining them separate from their parents in order to try to deter people from coming here. They stopped him from seeking to revoke protected status to dreamers, they're called, people who came to the United States illegally, but as children, with their parents, weren't responsible for violating the law. He sought to take away that protection. The court overturned that. Court overturned his efforts to deny access to immigrant teen women who were in federal custody, access to abortion. The environmental groups successfully challenged many of his efforts to undermine environmental protection and the like. So, it worked last time, and it worked because people came together and supported civil society. I said I was at the ACLU before Trump was elected. I used to say before I started at the ACLU, they had 400,000 members. Within 6 months of my start at the ACLU, we had 1.8 million members. And then, my daughter would say, Dad, there's a difference between causation and correlation, and it probably has something to do with Donald Trump, not you. But there was this outpouring. The New York Times subscription rates went through the roof. The Washington Post subscription rates went through the roof. The people created grassroots movements around the country. The Women's March was the first, the biggest march in world history, put together in the time between his election and Inauguration Day. It was just a tremendous amount of resistance, and it worked. It led some people within the Trump administration to push back. His attorneys general, Jeff Sessions and Bill Barr, both rejected his efforts to engage and politicize the Justice Department. The military pushed back against him, and the like. And then, of course, at the very end, the system worked in stopping his effort to halt the peaceful transition of power. He filed 60 lawsuits. He lost every one of them. He put tremendous pressure on local officials to recount, et cetera, and none of them did. And he left office with his tail between his legs, a shamed man. So they worked last time around. What's happening this time around? So as I said, he has targeted those very institutions. So how have those institutions responded? Well, it's a mixed record. On the one hand, you have a number of very powerful law firms that have capitulated to blatantly illegal orders. Rather than challenging the orders as illegal, they have entered settlement agreements with the president that have resulted in offering the president about $1 billion of pro bono legal assistance to support causes that the president agrees with. And the first firm that did this was Paul Weiss, but 8 other law firms followed in its footsteps. These are blatantly illegal executive orders. 4 law firms challenged them. In every instance, the courts immediately declared them illegal. They're so illegal that the Trump administration has not even appealed those decisions to the courts of appeals because they have no arguments. They're so obviously illegal. And yet, twice as many firms capitulated as as fought. Among universities, Columbia, as I'm sure many of you know, chose not to fight an equally illegal set of demands imposed on it by the Trump administration, and instead acceded to those demands, including changing the leadership structure of its Middle Eastern Studies Department at the behest of the president, and on some accounts, including getting rid of the president of the university because the Trump administration was unhappy with some of the things she said about that settlement. And some outlets in the press have also pulled their punches in various ways. The Washington Post declined to endorse Kamala Harris and changed its editorial page policy reportedly in order to placate Donald Trump. Paramount, which owns CBS, has been putting tremendous pressure on 60 Minutes, which is sort of the preeminent investigative journalism television show, to pull its punches and to alter its reporting. Meta stopped fact-checking posts because this is something that Trump was unhappy with. The president has no authority to mess with Meta's fact-checking, 60 Minutes' reporting, Washington Post's editorial choices. Those are all protected by the First Amendment, but rather than fight, these entities have acceded to the demands. But at the same time, many institutions of civil society have fought back. As I said, 4 law firms, led initially by Perkins Coie, have successfully challenged the orders against them. Harvard, as you know, is challenging Trump's actions against it and should prevail. Georgetown Law, where I teach, pushed back against the Trump U.S. attorney for the District of Columbia, who wrote a letter saying, if you don't get rid of all your DEI curriculum, I will never hire anyone associated with Georgetown ever again. The dean wrote back and said, it is part of our Jesuit mission to be committed to diversity, equity, and inclusion, and it's also part of our academic freedom, and we will continue to do so, and you have no right not to hire our people, and indeed they are hiring our people. Princeton's professor, Chris Eisgruber, very publicly has urged people to fight back and is fighting back against an effort to withdraw funds from Princeton. Many lawyers across the country have strongly condemned the actions of those capitulating law firms, and some big companies have left the capitulating law firm and gone to one of the fighting law firms, including Microsoft, which took its business from one of the capitulating law firms and went to Jenner & Block, which is one of the fighting law firms. Over 200 leaders of institutions of higher education have joined a statement supporting Harvard in its fight against the president. And many members of the media are reporting every day very aggressively on the abuses that Trump does every day. So it's a mixed record. Civil society advocacy groups like the ACLU, Democracy Forward, Protect Democracy, Public Citizen have filed boatloads of lawsuits against Trump initiatives. The ACLU alone has already filed 58 lawsuits. And the courts have continued to play an important checking role. They have already, we're about 4 months in, not quite 4 months into the administration, courts have already enjoined more than 165 Trump initiatives. More than 165 Trump initiatives. They have barred him from denying citizenship to people born in the United States where their parents were not U.S. citizens. They have stopped him from deporting foreign nationals to El Salvador under the Alien Enemies Act. They have blocked the shutdowns of numerous federal agencies, including the U.S. Agency for International Development, the Department of Education, the Consumer Finance Protection Board. They have freed several students who the administration has locked up for their pro-Palestinian advocacy. They have blocked executive orders against the law firms that I've already talked about. They have barred him from transferring trans women to men's prisons, from denying federal funds to hospitals that provide gender-affirming care to minors. And they've barred him from denying funds to cities and states that refuse to enforce his immigration agenda. Many of these rulings are preliminary and they're lower court rulings, so obviously what matters is what the Supreme Court does. But the Supreme Court has already engaged with a number of these cases on an emergency basis, has ruled that non-citizens have a right to due process and notice before they are put into deportation proceedings, even under the Alien Enemies Act. They have enjoined any deportations under the Alien Enemies Act until they rule on whether it's legal to use that law. They have denied a stay request of the Trump administration from the order barring him from shutting down USAID. They have also granted some emergency stays that the Trump administration has sought and thereby allowing him to kick trans people out of the military and allowing, on a temporary basis, and allowing him to remove heads of independent agencies without cause. So again, the courts, it's a mixed record, but it's a surprisingly robust record of resistance. So I think what all of this has revealed is two things. One, the vulnerability of civil society, the vulnerability of the checking institutions. But secondly, the interdependence of civil society and the checking institutions that can, I think, in many ways offset these vulnerabilities. So why are they vulnerable? So they're vulnerable for different reasons, but it ultimately comes down to money. It ultimately comes down to money. So the law firms are vulnerable and settled because many of their clients, big clients, need federal approval for deals and takeovers and things like that, and they just don't want to be on Trump's bad side, enemy list. They don't want to be associated with someone on their bad side. So even if the firm wins in court, they might lose significant clients, and that would come at a cost to their bottom line. And so a number of them have settled rather than fight. The universities, the press, and nonprofits, really the critical elements, I think, of civil society, are all dependent on federal subsidies in significant ways. Significant ways. The very fact that Harvard has $9 billion in federal funding that is at stake, that is at risk, shows how dependent the university is on federal support. The press, the broadcast press, it gets their access to the airwaves from the federal government. That's why the Federal Communications Commission can threaten to take away that access. They also get all sorts of tax benefits, and obviously nonprofits get significant tax benefits. When in the United States, when you donate to a nonprofit, the government basically takes that off of your taxes, so the government is providing a significant donation to that nonprofit as well. So that federal funding is critical to the robustness of these civil society institutions. They wouldn't be as robust as they are were it not for that support, but that makes them vulnerable. And Trump realizes that, and he has been very much exploiting that vulnerability. And the same thing with the law firms. He's exploiting the vulnerability to the market. Inside the executive branch, the vulnerability is that the president is ultimately the boss, and many of the internal checks in the executive branch are standards and norms that have been around for a very long time, not questioned for a very, very long time, but there's nothing to enforce them if the president decides, let's throw them out the window. And then courts. Courts are vulnerable because at the end of the day, they don't have the power to enforce their orders. They don't have a police force that they can send out to enforce their orders. They are reliant on who to enforce their orders? The president. And so if their orders are against the president, the only way those orders get followed is if the president chooses to follow those orders. And I've had many conversations with many journalists. What would happen if President Trump refused to abide by a Supreme Court order, for example? And there is a technical answer, which is that courts can hold contempt hearings. They can decide that a defendant is in contempt for having violated their order. They can then ask that that person be prosecuted for contempt. But who do they ask? The federal prosecutors who are under President Trump. And there's a provision in the law governing courts that says if the government refuses to prosecute, they can appoint an independent prosecutor to prosecute. But there's a very strong, quite strong argument that that provision is unconstitutional, that federal prosecution must be handled by someone accountable to the President of the United States because it's a core executive function. So there is really no way for the courts to enforce their orders unless the president agrees to abide by their orders. If he violated the orders, in theory, Congress could impeach him, but not this Congress. They're not going to impeach him. So so the court's orders, the court's power is also to some degree weaker than one might expect. It ultimately depends on a norm, a very fundamental norm, a norm that the loser has to follow the court's order even if they don't like the results and even if they are the President of the United States. That has worked. That has worked for the 200 plus years that we've been in existence. Almost 250 years that we've been in existence. I know that's a very short time, but that has worked. No president has defied a Supreme Court order, but at the end of the day, it is a norm, and that's it. And to some degree, these vulnerabilities of the checking institutions are inescapable. The executive needs discretion in order to do its job. And that gives it the discretion to reshuffle the internal executive branch and to use that discretion to take away funds from entities that he does not like. Civil society needs public subsidies to be as robust as it is. I think the American civil society is tremendously robust, but it is, without question, the tax-exempt status is a critical reason why it is. Unelected courts can't really have the power to enforce their own judgments in a democracy because that would put them above the law. So it is part of the checks and balances that courts are actually dependent on other entities to enforce their laws. So these vulnerabilities have become much more clear under Trump, but they've always been there, and to some degree they are inescapable. I want to close by just suggesting that at the same time as there are these vulnerabilities, there are also mutually reinforcing ways in which these institutions support each other and support each other in this core function of checking the government. So when people, there have been 2 polls taken in the last 2 weeks on should the president follow a court order that goes against him. And both polls have reported over 80% of Americans think they should. Now, you might think, well, of course, what about the other 20%? But in the United States, there's almost nothing that 80% of Americans agree on. We are an incredibly divided country, and yet remarkable agreement on this. And that public opinion is what will stop President Trump from defying a court order. Because when you go against what 80 to 85% of the American public think, that's not going to go well for you in a democracy. And civil society plays a critical role in reinforcing that very norm by bringing cases on behalf of people who have had their rights violated by powerful actors and calling on the courts to vindicate those rights and hold government accountable. They are every day sort of collectively acting in furtherance of that norm. So civil society builds that norm supports the courts. At the same time, the courts support the ability of civil society to do this critical work, principally through the First Amendment to the Constitution. So the First Amendment to the Constitution is, I think, best understood as a protection of civil society. Yes, it's a protection of the autonomy to read what you want and say what you want. Yes, it's a critical protection of self-government, but it is also a critical structural check on the abuse of power. So what does it guarantee? It guarantees the right to speak freely and criticize the government without consequence. It guarantees the right of a free press to report on the government without consequence. It guarantees the right to associate freely, which is what civil society institutions are. They are associations of people who have come together around a certain set of commitments to fight for one thing or another, or to educate, or to practice law. That is constitutionally protected by the First Amendment. It protects the right of assembly, the right to go into the streets, the right of the Women's March and Black Lives Matter, and now hands off, to go into the streets and generate opposition to government abuse. It protects the right to petition the government for redress of grievances, which is basically to file lawsuits challenging the illegality of the government. And it protects the freedom of religion, of independent, non-governmental communities that have a set of normative commitments that are not subservient to the government. So courts, by protecting civil society, First Amendment rights, protect civil society's ability to advocate for the role of courts to hold the president accountable. And that mutually reinforcing exercise is, I think, necessary, given the vulnerabilities that are inescapable, and essential if we are to survive the unhinged presidency. And that means we should be celebrating the acts of Harvard and Perkins Coie and others who have fought back against Trump, and condemning the decisions of Columbia and law firms like Paul Weiss to settle with the administration, notwithstanding the illegality of its actions. So, so this all leads me, and I'll leave you with this, to a quote from a judge by the name of Learned Hand, great name for a judge, He was said to be one of the greatest, maybe the greatest American judge not to be on the Supreme Court. He was an appellate court judge in the Second Circuit. Now that my wife is a judge, I have to say, well, maybe he was the greatest American judge not to be but he was a good judge. And he was asked in the 1940s to give a speech in Central Park in New York for a massive celebration for a naturalization ceremony where I think 100,000 foreign nationals were taking the oath to become Americans. And you know how different that time was. We were celebrating people coming from elsewhere and becoming Americans. And they asked him to give a talk to these new American citizens. And he called it the spirit of liberty. And he said in that talk, liberty lies in the hearts of men and women. When it dies there, no court, no law, no constitution can save it. While it lies there, it needs no court, no law, no constitution to preserve it. Now, like many good sound bites, this is an overstatement. We need courts, we need laws, we need a constitution to hold us to the promises of our better selves. But the core notion here that at the end of the day, it is up to us, it is up to the citizenry to defend and uphold civil rights and civil liberties is absolutely right. And if we survive the unhinged presidency, it will be because we are in fact doing that. Thank you.
Thank you, David, for an amazing talk. I know some people may have to go off and get food or whatever. If you do, then that's fine. But David has said that he will answer some questions. I'm going to abuse my position and ask the first one while I pour the water. If we survive, are you going to survive? Is the American Constitution going to survive?
I think so.
Good.
I've been accused of being an optimist. Sometimes I've been accused of being a naive optimist. No, but I think, I will say, I think this is the greatest stress test on our system since McCarthyism. And in some ways it's broader than McCarthyism. In some ways it's less sort of system-wide than McCarthyism, but it is a massive test. But we survived McCarthyism. There was a period of time where no one would stand in the way of Joe McCarthy. He was very much like Donald Trump. He was a charismatic, kind of uncouth, populist, anti-elitist bully. That's what he was. But he was effective, just like Trump is effective. And for a significant period of time, no one would cross Joe McCarthy. But inevitably he went too far. The tide turned. And not only did we survive, but some of our most critical First Amendment protections come out of the anti-communist measures, and the courts, after McCarthy had been censured, after he had sort of gone his fall, the courts saying, wait a minute, no, you can't hold people responsible. You can't hold people responsible for their being merely members of the Communist Party. You can't hold people responsible for merely advocating illegal conduct. Some of the protections that really make it very hard for the government to go after people today come from that era. So, I think it's quite possible that we come out of it. Look, horrific damage has already been done, not just in the United States, but around the world by President Trump, and that's going to take generations to recover from. But I do think we could come out of this in the United States with a better understanding of some of the vulnerabilities and some more better responses to those vulnerabilities, much as we did out of Nixon and Watergate, led to a lot of reforms that were that really sort of held some of the governmental abuses in check. So, you know, it remains to be seen, but, you know, my last point is really the point. You know, it ultimately depends on the citizenry of America. You know, do people stand up, push back, fight back, or accede? And thus far, while there have been a disturbing number of accessions, there have also been really courageous groups that have pushed back.
Okay. Right, I'm going to, I've got a hand here and a hand here, and then I'm, yeah.
Yes, thank you for...
Can I just wait for the mic, John?
Oh, sorry,
Thank
yes.
you. Thank you.
Thank you, really interesting talk, and you probably don't know, but just before you started, the court gave an injunction to prevent what they're doing in Harvard.
Oh, already? That
Actually.
suit was, it happened, that's how fast things happen these days, right? Trump announced this policy yesterday. This morning, Harvard sued, and they've already got an injunction against it.
But what I really wanted to ask you is whether you're perhaps being a bit too optimistic about civil society fighting back, because whilst I understand that as an abstract concept, should the president follow the courts, there might be an 80% chance. If you tweak that and said, should he obey rulings in relation to Venezuelan gangs or other unpopular groups, I wonder if the result would be the same. And what I really want to ask you is why is Congress being so quiet? Why are they being circumvented? Because he seems to be governing by fiat. Yeah.
So, those are two really good questions. You know, on, but now I already forgot the first one. The first, the second.
About the, whilst in the abstract.
Oh yeah. No, absolutely, a very fair point. And you know, there's a poll from that I talk about in my constitutional law class all the time, where they poll people: do you believe in free speech? And like 90% of Americans say yes. Do you believe that people should be able to burn flags without being prosecuted? And you know, 20% say yes. Do you believe that people should be able to engage in hate speech? And you know, 40% say yes. So yeah, when you get to the specifics, the hard cases, people pull back, and so there is that. But I think the norm is so powerful that, and it has literally never happened, including in Trump's first term, where he lost so many cases in the Supreme Court, and he followed every one of those orders. I also think it's significant that while he has evaded court orders in the ways that I described, which are outrageous, he has never argued, I don't have to follow the orders. What he has said is, I didn't violate the order. I interpret the order in this way, and you know, and therefore I didn't violate the order. Now the way he's interpreting it is bad faith, and the courts are, you know, calling him on that. But he is seeking to claim that he is abiding by court orders. He has not taken that step of saying he will defy court order. And in fact, that very question was asked of the president's top lawyer in the Supreme Court last week in a case involving the birthright citizenship case, and they asked him, if we rule that birthright citizenship is illegal, will you follow that across the country? And he said yes. So I just think maybe I'm optimistic, but I think people are being too I think many people are being too pessimistic on that score. Why is Congress not doing anything? Because it's Republican majorities in both houses. He has control of the Republican Party. He can, primaries are the name. If you win the primary in many places in the country, it's all about the primary. A Republican will be the representative in this district, no matter what, and because of gerrymandering and the like, or people moving and the like. And so all that matters is the primary. So all that matters is who's the most far right and who's favored by Trump. And so the Republicans, daren't go against him, and the Democrats don't have any majority power. So until the midterms, I think the Democrats will probably win the House in the midterms, and then you'll see a lot more at least oversight and sort of public checking by Congress. But right now they don't have the interest on the Republican side, they don't have the tools on the Democratic side.
Thanks. And a hand here.
I'll leave it to you to decide if this is actually a new question, because it's very much related to the first question of the gentleman. But the 80% poll sounds very nice, but in so many ways the greatest, or one of the greatest transgressions actually happened on election day, when people in this majority supported a candidate who had not just in the abstract said anti-democratic, illiberal things, but who had incited, entertained, supported an attempt at the violent overthrow of the American Constitution on the 6th of January. So I still find it very hard to believe, and I share faith and hope in civil society, but I find it very hard to uphold that hope in the face of a populace that
So-
has even made this second term possible.
Yeah, no, I mean, fooled you once. You know, the fact that he got elected again is remarkable, and a terrible sign about the American people. You know, it was a very close election, very close election. He won by ultimately a very small plurality, not even a majority, and so he didn't come in with some sort of mandate. And there was lots of reason to be unhappy with the Biden administration, and in particular the economy, and in particular the economy for people in the rural parts of the United States, which has been hollowed out by globalization and the like, which is, you know, associated with Democrats. And so, you know, and then Biden staying in the race as long as he stayed in, and then dropping out very late in the game, put the Democrats in a weak position. So there were a number of forces at play that made it very hard for the incumbent administration to prevail, and he happened to be the challenger. So yes, and I think a lot of people who support him think the claims that what happened on January 6th was an attempt to overthrow the government are overstated. That yes, it was violent, it was horrific, but it was basically a protest that got out of hand, and it wasn't in any way an actual attempt to overthrow the United States government with any chance whatsoever. And by calling it an insurrection and treating it that way, I think to some degree the Democrats lost a lot of folks who said, you know, these people were just, yeah, they did something wrong, but it wasn't an insurrection. So, you know, I don't think that the fact that he got reelected means that if he refuses to obey a Supreme Court order, people are going to rally to his defense.
Thank you for the very interesting talk. I've been...
I think the microphone's not on.
Or hold it closer.
Sorry, it might just be that I have a quiet voice. I've been following the bill that's going through the Senate right now, the budget bill, where there seems to be a clause that would limit the federal court's ability to hold basically the executive.
Sorry, it's quite hard to hear you. You have to project.
The bill seems to have a clause that would make it very difficult for the federal courts to enforce
Orders.
citations, contempt
injunctions.
citations. Yes,
Yeah.
excuse me.
Yeah, it's an outrageous provision.
Yes.
It is aimed, well, so I'll let you ask the question. What's the question?
I just wanted to, I was curious on your thoughts. I'm, of course, hoping it won't go through, but I don't have particular faith.
Yeah, so the provision basically says that if a federal court does not order a bond when they issue an injunction against a party, they can't hold that party in contempt, even if that party refuses to follow the order. It is designed to nullify the ability of the judge in D.C. who was overseeing the Venezuelan gang case his ability to hold the government in contempt, because he did not require a bond when he issued his injunction. And so if this were to pass, he would not be able to impose contempt. That law might or might not be constitutional. It won't, I don't think it'll have much prospective effect, because all courts would have to do is impose a bond when they issue an injunction. A bond, basically you come in and you ask for a preliminary injunction, a preliminary ruling barring the other side from doing something that's harming you. In many instances, but not by any means all instances, courts impose a bond on the party seeking the injunction, so that if we end up, on the final judgment going the other way, you can kind of compensate the party that was enjoined preliminarily. It happens mostly in business cases. It never happens in government cases, because the government really doesn't have that kind of harm to point to. And so courts just don't impose bonds when they're enjoining the federal government. They could, and they could make the bond $1. And if they make the bond $1, that law would not affect. So going forward, I don't think it would have any effect if it actually got enacted. I think there'd just be a kind of nominal bond imposed. But it's an outrageous effort by Congress by the Republicans in Congress, to basically take away the ability of this particular judge to impose contempt for this particular outrageous act of evasion, defiance, whatever you want to call it.
Okay, I can see all sorts of hands going up, but this one was here, and then I think I'm going to have to call it. I'm really sorry, but I think people are going to need to start to go, so this is going to be the last question.
It's a lot of pressure. I want to return to something, though, that I think has sort of woven its way in and out of a lot of your answers, which is the role of truth and strong conceptions of truth to supporting and substantiating a lot of these institutions. It strikes me that the press and the courts in particular depend on the idea that there's some truth to be found in law, or that there's some truth to the way events play out. And obviously, one of Donald Trump's part of Donald Trump's assault on these institutions has been to undermine the very idea of truth itself. And so I guess my question is, how do civil liberties institutions, how do all of these institutions respond to that, and how do they overcome that challenge?
Yeah. So I think it's a great question. I think it's not a new phenomenon. Joe McCarthy lied through his teeth, time and time again, made charges that were completely unsupported. And what you do is that's what the accountability mechanisms are for, right? The accountability mechanisms are to say, no, you can't lie and make it up. You can't, and the press is one accountability mechanism. And they're very, they used to be kind of shy about calling what Trump says lies. Now it's in the headlines, right? And the courts are another mechanism. And I do think I wrote an op-ed in the New York Times a couple months ago saying, in many ways, a lot of the things Trump has done are not actually totally unprecedented in the United States. I mean, we've done some pretty bad things over time. Presidents have done some pretty bad things. We've authorized torture. We've locked up people because they're Japanese. We've, gone after people for merely criticizing the war. We've done a lot of pretty bad things. But in the past, they've always been done in a time of war or some real national security crisis. After 9/11, World War II, World War I, those sorts of things. What's unprecedented about President Trump is he's taking these kinds of actions in the absence of any actual emergency. In the absence of any actual emergency. And in an actual emergency, it's very hard for courts to second guess what the president says and what the president says is necessary. And so you get decisions upholding the internment of the Japanese and Japanese Americans during World War II. But it's not quite so hard to call the president out when there's actually no emergency. And thus far, the courts have been, many courts have now taken up these Enemy Alien Act cases, and all but one have declared that the president does not have the power to deport people in the way he's doing under this statute. And the Supreme Court has now issued an injunction that says there will be no more deportations under the Enemy Aliens Act until we decide the case. And I would strongly predict that they will hold that he doesn't have the authority to do so. So, and that's a lie. You know, it is a lie. The Venezuelan gang did not invade us on behalf of Venezuela as an attack on the U.S. sovereign. It's obviously a lie. I think he will be held accountable for it. So, yeah, in a social media age, in the divided world that we live in, it's easier to propagate lies that are not checked within significant bubbles of information. But the best we can do is to rely on those checking institutions that allow us to hold government officials accountable when they lie. And those are courts and the press and civil society institutions.
Thank you.
Now, before I just draw this to a close and thank David for a wonderful, pretty sobering talk, I'd like to take up the theme of the last question and point out to the people who are here that next week, that's what we're going to go for. We're going to have Richard Ovenden, the director of the Bodleian Library, who's just written a terrific op-ed in the Financial Times about the Trump administration's decision to sack the director of the Library of Congress, even though it's the Library of Congress and not the Library of the President, but there we are, and the National Archives in America. And Richard, who wrote a fantastic history of attempts to suppress knowledge called Burning the Books, we'll be talking about attacks on knowledge, so do come along if you'd like to continue this conversation at 5:30 next Friday. But in the meantime, I want to thank David for a fantastic talk, covering an awful lot of ground, and very worthy of the memory of Jonathan Cooper. I wish Jonathan had been here and he would have been asking lots and lots of questions. Thank you very much.
Thank you.